Hey, I'm Bill Gross, the LA probate expert, and these are the questions I get asked most often as a real estate probate expert on a daily basis. Now, I want to say I'm not an attorney, I'm a real estate broker, but I deal with these activities every day and explain them to customers like you and other professionals in our industry every single day. So, this is what really my experience is based on seeing these probates in action over my 36-year career in real estate. So, question number one: what is probate? My good friend Tanya English taught me that probate is like when you die, you file a lawsuit against yourself, and after all the attorneys and court costs and processing fees and creditors and taxes get paid, the crumbs go to your heirs. And it's a rough way of looking at it, but in essence, probate is a legal matter that's tried in the county courts to determine, after somebody's passed, what happens to their personal estate, their finances, and their personal property. Second question is, where does probate process occur? And that's a loaded question because here we are still in the pandemic era, but it happens in local county probate courts, each county being different. In LA County, we used to have separate courts throughout LA County. About 5 years ago, they consolidated about 99% all downtown LA at the Stanley Moss Courthouse. A few were done in Antelope Valley, and a few are done when there's special cases at other courts, but almost all are done at the county courthouse. That said, with the pandemic, more than ever, you shouldn't need to go to court. If you have to show up for a hearing, most things can be handled via video or call in. There's special call in and video procedures, LA Court Connect being the video procedure, and it's free for all parties who are coming in at this time. And that's subject to change. Now, the actual court matter is downtown. Papers get filed online, and you can, work the process as you need to. But in general, you shouldn't need to go to court unless there's a contested matter or some sort of objection where you feel that getting in front of the judge is important for your matter. Number three, do I have to file probate if there's a will? This is the biggest misconception I get. I had a very good friend of mine, I don't want to say his name, who's an attorney who insisted that a will avoids probate. That's not true. It's not true, certainly in California. And in most states, a will is effectuated. A will is put into power through the probate court. A will is a piece of paper that you file with the court and then say to the court, hey, here's a will, probate court. Please give this document, this contract, the rule of law. And then if the judge approves it, then the will starts to take effect. Whether you have a will or not, you would still go to probate. With a probate, you're called a testate. Without a probate, with a will, you're called testate. Without a will, you're intestate, without testimonial will. Either way, though, unless there's some other matter of transferring the property, you're going to have to go to probate court with a will or without one. Number four, how can you find out if you're named in a will? Well, the only way to tell is by reading the will. And nobody's obligated to give you a copy of it until it's filed publicly with a court. Once it's filed with a court, it becomes public. That's why a lot of people prefer alternate methods like a living trust or other estate plans to keep those matters private. Because if you want to write a family member out of the will, they're going to find out when the will is finally done. So how can you find out? The answer is beforehand, whoever has the will would have to show it to you. And of course, it's subject to change. After the decedent has passed, you'll find out once the will is recorded, but until it's recorded with the court or filed with the court, you won't know about that. Number five, who are the heirs when there's no will or trust? So that's a good question. What happens if somebody passes and there's no clear line of delineation, meaning they didn't have a spouse, they didn't have children or grandchildren? Well, the answer is the court will look for the next of kin to determine, and there's a state law that determines how the order of precedence, parents and cousins and such. Most famous case I know of is Howard Hughes, who died without spouse, without children, but they had all kinds of cousins and it got split up based on the family tree. So there are services that I use and attorneys use to help find heirs. And then at some point, if there are no heirs, any money that's left over will end up going to the county. But definitely, there is research done, and it's not just their immediate children or spouse, but it'll actually be their parents, their siblings, their nieces and nephews and such as well. Number 6, how long does a probate take? Well, it'll take as long as it takes. In fact, it really shouldn't take more than a year unless there's some special circumstances because you file for probate, theoretically, you have a hearing in 30 days. If you do your job right and you have full authority, you're empowered then. You take care of the matters at that point and file an accounting at the end. Truth is, though, most probates in Los Angeles County take well more than a year, on average about 2 years. The average property is sold after about 2 years. Why does it take so long? Well, probate is a very paperwork, detailed, intensive business. And many attorneys, I would say 95% of attorneys, have not done a probate in the last year. And so they'll make minor mistakes that the court will kick back the paper for and cause a hearing to be delayed 30 days, another 30 days, another 30 days. There's really no shortcut. You have to follow the rules and procedures of probate in order to get to the end, which is when the money is distributed. So many cases it takes 2 years. When there's contests, when there's objectors, when there's people fighting over the money, it can take literally years and years. I've seen probates last 10 years when there's fighting, but no fighting. It should not take more than a year, but often does because of mistakes made by the families or the attorneys. Number 7, when to get my inheritance. Well, here's the thing to know. Everybody gets paid before the heirs. So they file the probate, the court gets paid. They have to advertise the probate, the newspapers get paid. The attorneys get paid, the creditors get paid, taxes get paid, and at the very end, whatever's left at the very end is split up amongst the heirs. When the court approves it, those checks are cut and they get paid. So really, I would say that the heirs get the money in a probate case at the very, very end. Number 8, when's probate not necessary? Well, there's a lot of cases where full probate might not be necessary, is when the assets are below the threshold and there's more of a paperwork process, affidavit process. If it's below in California, $167,000. So maybe there's no property or there's only a portion of a property, and that would be one example. Another case may be that, of course, so there's no assets at all to split up. More common case when there's no probate needed is when there's some estate planning done ahead of time. Either the property that is there is titled husband and wife, it will pass to the spouse in many cases, or an estate plan has like a living trust where when somebody passes, their assets are already defined in the trust how they get passed. That's why I recommend to all my clients that own a property to get an estate plan, most commonly a living trust. If you have questions, that reach out to me. But I use a service that's very inexpensive to at least get a basic one done. And if you have more complicated finances, you should meet with a proper estate planning attorney. Number 9, what happens to the house when there's no will? Well, again, the house, assuming that nobody else owns it but the person who passed, the decedent, we have to decide who gets the house. And if there's no will, whether there's a will or not, it's going to go through probate unless there's some other process. If there's no will, the property will pass eventually to the heirs, and the heirs can decide to sell it or the heirs can decide to keep it, depending on who they are and what they want to do with the property. Number 10, what are the executor's duties? Well, an executor is somebody who is appointed by a will to execute the will according to the decedent's wishes. And really, it could be anything that the will requires or the estate requires. So I've seen executors have to deal with trashing out property, estate sales, firearms, firearms with the serial numbers taken off, which have to go to law enforcement, cars towed, tenants evicted, squatters removed, drug people kicked out of the house and the house is burning up. I have seen all kinds of things. And those are the executor's duties, but the executor can work with attorneys and real estate professionals to get services needed to support them. So the executor is ultimately responsible for everything, but they can appoint duties to other vendors like me to get those things done for them. Number 11, I don't live in the area. Do I have to be there in person? Well, no. And that's not uncommon, actually, where somebody has passed here in Los Angeles and the family member remaining is out of state. So that's why you want a local real estate professional like me who knows probate and can help guide you to the attorneys and the other services you need to get the property taken care of. So it's very common, but the key is you want to make sure you have a team of people who are going to help you, be your eyes and ears on the property. In my case, I work with a national company, so I have team members all over the United States. I literally took a listing last week where the heirs live in Bakersfield, the attorney is here in Los Angeles, and the property is in Oakland. And we were able to see the Oakland people. I was here in LA, and the heirs were able to send the documents electronically. So it doesn't matter where you are. I can help you, and any good real estate professional probably can help you as well. Number 12, number 1, 2, 12, probate litigation. What is probate litigation? Well, there's a standard probate, 99% of them, and there's the 1 in 100 where there's another party who raises their hand and says, hey, I disagree with what you're doing. Commonly, there's multiple siblings. If they didn't get along when mom or dad were alive, they're not going to get along when mom and dad have passed. And so oftentimes one sibling is concerned, the other sibling is going to cheat them. Now, I find the cause of that is poor communication. Oftentimes, I'll be the intermediary to try to get them to get along, explain both of them the rules, show them the protections they have, and maybe encourage both parties to have their own separate attorney to make sure that their needs are represented. But litigation is just any kind of, like any litigation, there's a dispute, there's at least two parties, maybe more, and they're arguing over something that they want done, and they're going to take it to the court to decide. And I can just tell you, it's very expensive and very time consuming. 13, what should I do to prepare for a meeting with a probate attorney? Well, the more information you have, the more efficient your meeting will be. But I find the good probate attorneys have an intake process to help you know what that means. So you're going to have statements, bank statements on any accounts, any mortgages, insurance, taxes, if you have tax returns, 1099s, W-2s, any of that kind of legalese information will help them move the process along. But again, if you have questions on that, see me, but because we have an intake sheet that we use to help you in gathering that information. The more information you get in your own, the better, but sometimes you can't find it. Sometimes, the records are in the house and you can't find where they are. And so that's where we bring an accountant in sometimes and empower them to do some research to find out where records might be. Other times we use private investigators. If we think there's bank accounts, there's evidence of a lot of money, we've hired recovery asset specialists and private investigators to actually find those assets. Number 14, what do I need to know about probate in my state? Well, here's what I'll tell you. State laws vary in every state, and procedures vary within a state in almost every county. So you really want to make sure you know somebody who has connections to those local areas. What I do when I have a client who has a case in another county or in another state, I'll reach out to my network. Now I run a weekly, probateweekly.com, a Zoom call with 60, 70 people every week. I interview attorneys all around the country. And so I'll reach out to attorneys for referrals, meet the attorney, try to vet them for my clients. I also work with certain services that are national that can help a customer file their probate case in 50 states. So again, what do you need to know about as an individual? Just know the laws vary and the procedures vary, and make sure your team is able to effectuate what you want done in that area. Number 15, what happens to the assets during the time of the probate process? Meaning, what happens with the house? What happens with cars and such? And the answer is initially nothing. When the probate is filed, the estate doesn't have the authority at that time to do much. Now, if there's an emergency, you can file for emergency authorization. It varies in different counties and states, but you can have an attorney file a motion to, let's say, have a temporary administrator to handle property or to do things that might be requiring protecting the assets or life and health. So I've seen cases where they can get some money set aside initially for healthcare, for medical bills, for adult care facilities, adult care givers, and such. So there's ways you can get that done. But in general, during the probate, you don't have access to the assets. Once the probate's filed, and then the court at some point approves the administrator executor of the estate, now they can make decisions and start spending money or utilizing the assets. So at that point, they can move cars, tow cars, secure properties, get money from bank accounts, pay bills, and things like that. So what happens during the assets really is very hard until you get the approval to be the authority for the probate. Number 16, how much does probate cost? That's a great question. I would say that it doesn't have to cost a lot. It depends on your particular case. In general, there are statutory limits on probate. In California, for example, you can't charge more than a certain amount, but attorneys can charge less. And most attorneys that I work with have a minimum. because they know their time is worth something, and they'll charge minimum $5,000 or $10,000, and they'll want a retainer upfront to start. That said, I work with a service, easy-probate.com, that can do a basic probate and do, in my opinion, a good job on a basic probate for as little as $700, and they have a concierge package for about $1,200. If you don't have the money, we can help you advance the money as well. We can put that fee on a credit card. So how much does it cost? That's just the probate fee or the attorney's fee. Then you have filing costs, which could be waived in case of hardship. You have advertising costs to advertise the probate. And if you're selling a property, maybe to advertise the sale of the property. So it varies based on your case and how many assets you have and what state you're in. I would budget a minimum of $2,000 in California. And if there's no contest, if everybody's on board, if you have a couple siblings who are fighting for the right to be the leader, and it's going to be a litigious situation, it could be $10,000, $20,000 or more. The last question, number 17, how can I avoid probate? My favorite question. If there's a way to, it's helping people avoid the attorneys and the courts and the legal fees and the filing fees and the advertising fees and the drama of probate court. How do you do that? In general, if you own a house in California, for sure, you should have a living trust or some other estate plan to keep the property out of the probate process. That way, whenever you pass, the property is transferred based on your goals and wishes. Not only that, should you become incapacitated, God forbid, you can't make your own decisions, maybe medically you're not able to, or you have some sort of cognitive issues, the trust will come with other documents to give power to, if necessary, sell the property, use it for medical care, or whatever is most appropriate for your support. So how do you avoid probate? Answer: get with a estate planning attorney or estate planning service to make the plans to protect you before you need it. I find that if you plan ahead, you'll save half, 2/3, 3/4 of the money you'll spend if you don't save the money ahead of time. Thanks for this. I'm Bill Gross, the LA probate expert. I host every week probateweekly.com for free. Love to see you there. Call me, text me, email me if I can help in any way. Thanks.